Long ago, at the very beginning of the 19th century, the United States was still a young nation. The country was trying to understand how power should work, who should control what, and how laws should be interpreted. There were no skyscrapers, no internet, no television, only ink, paper, and long political arguments written by candlelight. In the year 1801, America had a change in leadership. John Adams, the second president of the United States, was about to leave office. Thomas Jefferson was preparing to take his place. This transition was calm on the surface, but underneath it carried quiet tension. Before leaving office, President Adams made several last-minute judicial appointments. These judges were later known as the Midnight Judges because the documents were signed very late, almost as if time itself was running out. One of these appointments was for a man named William Marbury. Marbury was chosen to be a justice of peace in Washington, D.C. His commission was signed and sealed, but something small, almost forgettable, happened. The paper was never delivered to him. When Thomas Jefferson became president, he ordered his Secretary of State, James Madison, not to deliver some of those remaining commissions. Jefferson believed the appointments were unfair and rushed. Marbury, however, believed the law was on his side. Instead of protesting loudly or starting a public fight, Marbury did something very quiet and formal. He went to court. He asked the United States Supreme Court to order James Madison to deliver his commission. This type of order was called a writ of mandamus, a legal command telling a government official to perform a duty. At that time, the Supreme Court was not as powerful as it is today. It met in modest rooms, and people did not yet see it as the final authority on the Constitution. The Chief Justice then was John Marshall, a calm, thoughtful man who spoke carefully and chose his words slowly. The court now faced a gentle but important question. Did William Marbury have a right to his commission? And more importantly, did the Supreme Court have the power to force the government to act? These questions were not answered quickly. They were considered slowly, quietly, and with great care, just the kind of thinking that drifts easily into sleep. And this is where the story pauses for now. A quiet decision that changed everything. The courtroom was not loud. There were no cameras, no microphones, and no applause. Only papers, soft footsteps, and long pauses between spoken words. Chief Justice John Marshall began by addressing the simplest question first. Yes, William Marbury had been properly appointed. Yes, the commission had been signed and sealed. And yes, under normal circumstances, he should have received it. But then came the slower, heavier question. Could the Supreme Court actually order the Secretary of State to deliver that paper? Marshall carefully examined the law that Marbury relied on, the Judiciary Act of 1789. This law said the Supreme Court could issue writs of mandamus in certain cases. The words were written plainly, but their meaning carried deep consequences. Marshall compared that law with the United States Constitution, and in a calm, almost gentle way, he noticed something important. The Constitution listed the types of cases the Supreme Court could hear originally. Marbury's case was not one of them. This meant something subtle but powerful. If Congress had passed a law that gave the court more power than the Constitution allowed, then the law itself could not stand. There was no anger in this realization, no dramatic pause, just logic moving slowly from one sentence to the next. So the court reached a quiet conclusion. William Marbury was entitled to his commission, but the Supreme Court did not have the constitutional authority to force James Madison to deliver it. And so Marbury lost his case. Yet something much larger happened in that silent room. For the first time, the Supreme Court declared that a law passed by Congress could be unconstitutional. This idea became known as judicial review. No one stood up, no one clapped, most Americans barely noticed. But from that moment on, the Supreme Court became the final interpreter of the Constitution, slowly, patiently, case by case. As the ink dried on the decision, the room returned to stillness. The papers were stacked, the judges went home, and American law quietly changed forever. The year was 1824. America was still stretching outward, quietly growing, one river at a time. There were no highways yet, no airplanes, no long-distance trains. Instead, the nation moved by water. Rivers carried crops, letters, passengers, and patience. Steamboats traveled slowly, their engines humming in a steady, comforting rhythm, perfectly suited for long thoughts and heavy eyelids. At the center of this story was the Hudson River, flowing calmly between New York and New Jersey. New York had given two men, Robert Livingston and Robert Fulton, an exclusive license to operate steamboats in its waters. This meant no one else was allowed to run steamboats there without permission. Later, a man named Aaron Ogden received part of that monopoly. Another man, Thomas Gibbons, did not. Gibbons operated his steamboats under a federal license granted by the United States government. He believed this license gave him the right to navigate freely between states. Ogden disagreed. Instead of arguing loudly on the riverbanks, they went somewhere much quieter, the Supreme Court. By now, John Marshall was still Chief Justice, older, calmer, and very familiar with careful reasoning. The question before the court was not rushed. Could a state control commerce that crossed state borders, or did that power belong to the federal government? The word commerce was read slowly from the Constitution. It was not limited to buying and selling. It included navigation, movement, the gentle act of traveling. Marshall concluded in a steady and unhurried voice that when commerce moved between states, it belonged to the national government, not individual states. New York's monopoly, though granted with confidence, could not stand in the way of federal law. So the court ruled in favor of Thomas Gibbons. Steamboats continued their slow journeys. The river flowed on, and the federal government's power over interstate commerce quietly expanded, without celebration, without resistance, and without waking most of the nation. This decision would later shape railroads, highways, and trade, long after the sound of steamboat engines faded into history. The year was 1857. The United States was larger now, but not calmer. The country was divided, though many people pretended it was not. The arguments were everywhere, spoken softly in homes, whispered in courtrooms, and written carefully into law books. At the center of this quiet storm was a man named Dred Scott. He was an enslaved man who had lived for a time in free territories, places where slavery was not allowed. Because of this, Scott believed something simple and human, that living on free land had made him free. With patience and hope, he brought his case to court. The case moved slowly, as most things did then. Years passed, judges changed, papers aged. Finally, the case reached the Supreme Court. The justices did not hurry. Chief Justice Roger B. Taney wrote the court's opinion. His words were formal, measured, and deeply cold. The court ruled that Dred Scott was not a citizen of the United States. Because of this, they said, he had no right to sue in federal court. Then the decision went further, quietly but heavily. The court declared that Congress did not have the power to ban slavery in U.S. territories. Laws that had tried to limit slavery were brushed aside with ink and authority. There was no immediate noise, no shouting in the courtroom, no sudden change in the streets. But the silence carried weight. The decision did not settle the issue of slavery. It hardened it. Many Americans read the ruling in still rooms, late at night, by dim light, feeling uneasy without fully knowing why. Dred Scott himself did not gain freedom through the court. History would later remember the case not as a solution, but as a warning. A few years later, the quiet tension would break into war. For now, the books were closed. The judges stepped away. The nation continued forward, uneasily, slowly, and without rest. The year was 1952. The world was tense, but the courtroom was not. Outside, the Korean War was underway. Factories worked steadily, producing steel for ships, tanks, and bridges. Steel was important. Without it, many things would simply stop. Inside the White House, President Harry Truman worried about a steelworkers' strike. A strike could slow production, and slowing production felt dangerous in a time of war. So the president made a decision. Without asking Congress, Truman ordered the government to take control of the steel mills, temporarily, he said, for the good of the nation. The steel companies did not shout. They did not resist with force. They went quietly to court. The case arrived at the Supreme Court. The question was simple but deep. Could the president take private property without approval from Congress, even during wartime? The justices considered the matter slowly. They read the Constitution. They reread it. They compared power to restraint. In a calm majority opinion, the court said no. The president's power, though important, was not unlimited. Even in times of danger, the Constitution remained in place, steady and unmoving. Justice Robert Jackson wrote a thoughtful concurrence, explaining that presidential power is strongest when supported by Congress, weaker when Congress is silent, and weakest when acting against Congress. His words were not dramatic. They were balanced, measured, carefully arranged. President Truman accepted the decision. The mills returned to their owners. The strike eventually ended. The war continued, and once again, the Supreme Court had quietly reminded the nation that power flows best when it stays within its boundaries. The year was 1965. America was louder now. Cars, radios, televisions everywhere. But this case was not loud at all. It was about something private, something quiet, something that usually stayed behind closed doors. The state of Connecticut had an old law, very old. It banned the use of contraceptives, even from married couples. The law was rarely enforced, but it still existed, resting silently in the books. Two people challenged it: Estelle Griswold, who worked at a Planned Parenthood clinic, and Dr. C. Lee Buxton, a physician. They believed the law went too far, into places the government did not belong. Instead of protesting in the streets, they chose a slower path. They went to court. When the case reached the Supreme Court, the justices faced a gentle but unusual question. Did the Constitution protect a right to privacy, even though the word privacy was never written in it? The justices read the amendments carefully. The first, the third, the fourth, the fifth. In the spaces between those words, the court found something soft. Justice William D. Douglas wrote that certain rights create penumbras, shadows, quiet outlines where privacy lives. Marriage, he said, was one of those private spaces, a place where the government should not enter quietly or loudly. So the court struck down the Connecticut law. There was no sudden change the next morning, no sirens, no announcements, but the idea of constitutional privacy had been gently placed into American law. Years later, this quiet idea would grow into larger, louder cases. For now, the decision rested calmly, like a book closed halfway through a long night. The year was 1969. The country was busy. The news was loud. But this story began in a school hallway. A group of students in Des Moines, Iowa, decided to do something very small. They wore black armbands to school to protest the Vietnam War. They did not shout. They did not disrupt class. They simply wore the armbands and stayed quiet. The school officials were uneasy. They believed the armbands might cause trouble, so they suspended the students. The students, calm but determined, challenged the decision. Slowly, carefully, the case made its way to the Supreme Court. The question before the court was gentle but important. Do students lose their constitutional rights when they walk into a school? The justices took their time. In a measured opinion, the court said no. Students, the court explained, do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. As long as speech does not cause substantial disruption, it is protected, even when it is silent. The black armbands were not loud, they were not violent, they were simply present, and that was enough. The decision settled quietly into law. Classrooms returned to their routines, hallways filled with footsteps again. The armbands were folded away, but the idea remained that even small, silent acts can carry meaning, and that the Constitution listens even when voices are low.